We're live. Let me just check the Facebook page. Yes. We're live.
Perfect.
So I can close Facebook. Okay. I think we can just wait maybe 1 minute before we start.
Sounds good. I just got the notification that we're live, so.
Okay, great. Yeah. How are you?
I'm good.
Thanks for joining us today.
Thanks. How are you doing?
I'm good.
It's a Friday, at least, right? Like
it is, yes.
So.
Long weekend, yeah.
Oh yeah, a long weekend. I didn't even think of that.
I think we can start.
Okay.
Yeah.
Sure.
I'll just I will start with an acknowledgement. So I'd like to begin by acknowledging the traditional and unceded territory of the Algonquin Nation on which we are working and organizing this event today. Thank you for joining us. We can see the comments and the questions, and we will be very happy to answer the questions towards the end of the presentation. We'll have 10 to 15 minutes. So feel free to ask your questions on the chat. And yes, the presentation will be available after. It will be uploaded on YouTube, and we'll make sure to share the link on Facebook. And if you can't find it, you can always email us and we'll send it to you. This presentation will offer you an overview of the law as it pertains to HIV non-disclosure. We will go over some of the key demographics and harmful consequences of criminalizing HIV non-disclosure, as well as different scenarios that do or do not constitute grounds for criminalization according to the law as it currently stands. We will also review some of the important work that is being done in Canada to change the law and how you can get involved. During the presentation, I will share some useful resources in the comments section in the chat. And I will also share ways to contact Katarina. Katarina, we're very happy to have you as our guest speaker today. Katarina uses she, her pronouns and is a doctoral candidate in the Department of Criminology at the University of Ottawa. Her project explores the emotions and feelings of experiencing HIV non-disclosure from a sexual partner and how these shape decisions to report or not report partners to the police. She grew up in Vancouver and moved to Ottawa in 2016 for graduate school. You can catch her along the canal, riding her back, or at home, snuggled up beside her cat and a good movie. Again, thank you, Katarina, and we are ready to start. We can start whenever you're ready.
Okay, let me just share my screen. I don't know why it's like halfway like that. Of course, we tested this out then. There were no technical difficulties, and now there are.
Okay, great.
Yeah, I mean, worst comes to worst, we can just do this if it doesn't want to function today. Okay. So thanks, Khaled, for that introduction. And my cat might make an appearance. He's very loud, so he might say hi. And usually when I do these presentations, he thinks I'm like talking to him. So yeah, sometimes he says hi. And I do have construction also. So if you hear some like rings or bangs. It's that. And thank you all for coming and for watching, whether you're live today or whether it's going to be later on YouTube or somewhere on the interwebs. Thank you. Welcome. So I just want to preface this presentation by saying that I'm not a law student. I'm not a lawyer. I'm in criminology. So anything that I'm presenting to you today is simply information about the legal landscape of HIV non-disclosure in Canada that I've sort of read and researched over the years from organizations like the HIV/AIDS Legal Network and HALCO. So nothing that I say today is legal advice. But if you do feel like you need legal advice after listening to what I've said today, Khaled will post those links in the comments and also on YouTube in the description as well. Okay, so how many people are criminalized for HIV non-disclosure? So sort of based on the latest information that we have, we know that over 200 people have been criminalized for allegedly not disclosing their HIV status to their sexual partners. So Canada is actually the world leader in per capita prosecutions for HIV non-disclosure. So this basically means that we've actually pursued these cases quite a lot compared to other countries. And we also know that from 1989 to 2016, 55% of all cases in Canada have occurred in Ontario. And I think it's also important to note that about 70% of cases related to HIV non-disclosure end in a conviction on at least one of the charges brought forward. So this is interesting, particularly because the conviction rate for sexual assaults in Canada, so other sexual assaults in Canada, when based on the number of charges laid, is estimated to be about 27%. So cases of HIV non-disclosure seem to almost be sort of more easy to convict, but we don't really know why this is. And plus, it's actually really hard to compare these two things because the estimates for the conviction rates really vary depending on how they are reported and the sources of statistical data. So it's really hard to come to any kind of conclusion about what this means, but it's still an interesting thing to point out. So we also have information about who is being criminalized. So of the people whose race we know, white and Black people represent the majority of people who are criminalized for HIV non-disclosure. And specifically, white people represent 33% and Black people represent 23% of people criminalized for HIV non-disclosure in Canada. And you can also see from the chart, I know it's really tiny and I apologize for that, is that the race and or ethnicity of 34% of the people is actually unknown. So maybe these numbers are higher, but we don't really know. We also know that 42% of women who were charged for allegedly not disclosing their status to their partner before sex are Indigenous. And so Indigenous women actually represent a large proportion of the women who are criminalized. And in terms of gender and sexual orientation, most people who are criminalized are men, and they represent about 88% of people who have faced charges relating to HIV non-disclosure, while women actually account for 10% of all people charged. And of course, this information is up until the end of 2016. So I think there's new data that is hopefully being updated and will come out soon. Although we also know that the number of women who are charged is slowly growing. And the majority of people criminalized for HIV non-disclosure are actually heterosexual, although the number of gay or bisexual men charged has increased since 2012. So this means that all of the female defendants and 62% of male defendants face charges related to HIV non-disclosure in the context of heterosexual sex, while 25% of men criminalized for HIV non-disclosure face charges in the context of sex with male partners. People who are criminalized for HIV non-disclosure have also been on the receiving end of really harsh attacks in the media. So as you can see from some of these headlines, people living with HIV who are criminalized for allegedly not disclosing their HIV status to their sexual partners are depicted as sexually deviant, sexually assertive, promiscuous, and therefore dangerous. And as I mentioned earlier, we know that Black men represent the second largest group of people who are criminalized, yet they're reported on in the media the most. And so one report actually found that 62% of news articles focus on racialized defendants, while only 24% focused on white defendants. So, for example, for my master's thesis, I actually analyzed the construction of TS, and I use abbreviations in order to protect the privacy of these folks as much as possible. So I analyzed the construction of TS in the media. And so TS was a Canadian football player. He was a celebrity who was criminalized for HIV non-disclosure. And what I actually found was that although TS was initially constructed as this sort of sports hero, once news broke of his HIV status and that he was being charged for allegedly failing to disclose his status to the two complainants, he was quickly linked to racialized tropes of hypersexuality, aggressiveness, size, dangerousness, and criminality. So the media really paints a problematic picture of people criminalized for HIV non-disclosure. And it's one that's really meant to sell newspapers or increase viewership, while actually failing to account for how that might actually affect the individual they're writing about. And really, this kind of reporting only increases stigma, and it works to kind of create a sense of fear in the public of people living with HIV. So now to get a little bit into the law of HIV non-disclosure in Canada. So there are two main cases in Canada that dictate how courts try cases of HIV non-disclosure. So the first occurred in 1998 and set the precedent for other cases. So in RV Courier, the Supreme Court of Canada concluded that people living with HIV have a legal duty to disclose their HIV positive status to sexual partners before sex that poses a significant risk of HIV transmission. And unfortunately, the court didn't actually specify what they meant when they said sex that poses a significant risk. Not to mention that, what one person deems as sort of significantly risky is not the same as what another person might deem as significantly risky. So, of course, there's definitional problems here. And sort of the other important detail of the Courier case is that the judges of the Supreme Court decided that not disclosing your HIV status before sex that poses a significant risk actually amounts to fraud. So under the criminal code, consent to physical contact, such as sex, is not valid if it's obtained by fraud. So otherwise, consensual sex is turned into a sexual assault under the law, and it's treated the same as forced or coerced sex. So then the charge is usually elevated to an aggravated sexual assault, as the courts have considered that exposing a person to the possibility of acquiring HIV actually endangers the life of the person who is exposed. And so since there were so many discrepancies amongst the lower courts in terms of what actually poses a significant risk of HIV transmission, the Supreme Court decided to hear another case in 2012. So in RV Mabier, the Supreme Court of Canada decided that there is a legal duty to disclose one's HIV status before having sex that poses a realistic possibility of HIV transmission. So what this basically means is that if a person living with HIV wears a condom and has a low viral load, which the courts define as having less than 1,500 copies of virus per milliliter of blood, the person living with HIV does not have a legal duty to disclose. So the courts decided that this scenario is one that doesn't pose a realistic possibility of transmission. That being said, if someone living with HIV doesn't disclose their status to a sexual partner before having sex when there is a realistic possibility of transmission, so this means when the person living with HIV doesn't have a low viral load, or doesn't wear a condom, they could be charged with an offense. And I think it's important to also note that Canada doesn't actually have a specific law that criminalizes HIV non-disclosure. So instead, what Crown prosecutors do is they use existing laws in the criminal code. So there have been cases where people were charged with things like criminal negligence, causing bodily harm, and assault. But the most common charge actually is aggravated sexual assault, which is one of the most serious offenses in the criminal code. So it carries a maximum penalty of life imprisonment and mandatory lifetime registration as a sex offender. And conviction for this offense also means that any person who is not a Canadian citizen, including permanent residents who may have lived for many years or their whole life in Canada, could face deportation. So before we move on, I do want to note that even with the laws that we have, people living with HIV have been charged even when they did not intend to transmit the virus. They engaged in behaviors that pose little or no risk of transmission, such as having sex with just a condom, but not a low viral load. And in some circumstances, they didn't, in fact, transmit HIV to their sexual partners. So actually, we know that in about 60% or 61% of cases of HIV non-disclosure, there was no transmission of the virus. So the courts haven't really been able to come to a consensus about what is a realistic possibility of transmission. I mean, it's pretty vague. So this is why advocates have been calling on attorney generals of the provinces and federal government to put out federally binding directives that would limit the unjust use of the law to criminalize people living with HIV. So just before we get into all of the different scenarios, I did want to show this video from the HIV/AIDS Legal Network about what a person should do if they are charged with HIV non-disclosure. And it also gives you all a little break from my voice. So hopefully this works.
As a person living with HIV, what should I do if I'm charged for allegedly failing to disclose my HIV positive status? If you're concerned that you're being charged or if you're being contacted by the police, you should really try to contact a criminal defense lawyer as soon as possible. You can ask for a referral at the Canadian HIV/AIDS Legal Network. We know some lawyers who are familiar with cases of HIV non-disclosure, which can be helpful. If you are contacted by the police or detained, you need to remember that you are under no obligation to answer the police officer's question other than your name, address, and birth date. And you have the right to speak to your lawyer in private before that and without delay. If you are not a Canadian citizen, you're an immigrant or you're a refugee, you should also contact an immigration lawyer because prosecution for HIV non-disclosure could have an impact on your immigration status.
Perfect. Okay, so now we're going to get into a few different sort of scenarios, legal scenarios that have occurred. So just as a quick review, so we know that the Supreme Court has said that if a person living with HIV has a low viral load, so below 1,500 copies per milliliter of blood, and wears a condom, there's no legal duty to disclose. However, there are scenarios in which people have been charged even though they took precautions. So just a quick review on the meaning of viral load. So the definition of this concept is the measure of the amount of HIV in a person's blood. So we now know that with effective treatment, a person's viral load can drop significantly so that they are undetectable, which means there's no risk of HIV transmission, hence why we use the common term U equals U. And just to sort of clarify, the law in Canada, as of right now, states that a low viral load is 1,500 copies of virus per milliliter of blood, while undetectable or suppressed viral load is defined as having equal to or less than 200 copies of HIV per milliliter of blood. So these are sort of important distinctions moving forward. So currently, federal Crown prosecutors and provincial prosecutors in the territories and in Ontario, British Columbia, and Alberta operate under some policy directive or instruction to not prosecute people who had maintained a suppressed viral load. So in other words, under 200 copies of HIV per milliliter of blood at the time that they had sex, whether or not a condom was used. There are some variations in how this position is worded, though. So for example, in Ontario, the policy states that there will be no prosecution when someone living with HIV is taking treatment and has maintained a suppressed viral load for 6 months. So this policy is really in line with scientific evidence and has been emerging in some court decisions. For instance, in Ontario, there have been people whose charges were dropped by prosecutors because the person living with HIV had an undetectable viral load, but didn't use condoms at the time they had sex with their partners. So the courts have decided that there was no realistic possibility of transmission in these cases because the scientific evidence demonstrated that their risk was not significant. However, there have been cases to the contrary, and there has not been a Supreme Court ruling that would make it clear across the country that a suppressed viral load is sufficient to avoid prosecution. So while it's not officially defined in any policy, given the available science and the emerging situation is that someone with an undetectable viral load is unlikely to be prosecuted and unlikely to be convicted for HIV non-disclosure in Canada, whether or not they used a condom. So our second scenario, sex with a condom and an unsuppressed viral load. So experts have confirmed that HIV cannot be transmitted when a condom has been used correctly. We know that HIV does not pass through an intact latex or polyurethane condom. However, the law on this issue is very much still evolving. So in Ontario and Alberta, for example, provincial policy and instructions for prosecutors are silent on the question of condom use. But the HIV/AIDS legal network has been in conversation with the Ontario Ministry of the Attorney General, who has said that someone living with HIV who uses condoms is still at risk of prosecution if they have a viral load that is higher than low or higher than 1,500 copies of HIV per milliliter of blood. So there are also conflicting court decisions on this issue, right? We know that in Ontario, there was a young man who was convicted for not disclosing his HIV positive status before sex, even though he used a condom but didn't have a low viral load. And I believe this decision is currently being appealed. So we're sort of looking out to see what happens. So what can we conclude from this? Okay, the law and decisions to prosecute are still unsettled in cases where a person has an unsuppressed viral load, but a condom was used. So in other words, there's still a risk of prosecution if the case is that the person living with HIV has an unsuppressed viral load, but has sex with a condom. So our next scenario is sex with a low viral load and no condom. So just to reiterate, we know that science shows us that when a person living with HIV has a low but still detectable viral load, which is between 200 and 1,500 copies of HIV per milliliter of blood at the time of sex, the possibility of HIV transmission through condomless sex ranges from negligible to none. However, there is no directive or policy currently in place in any jurisdiction in Canada that deals directly with this situation. So a person living with HIV in this circumstance remains at risk of prosecution. And we know of at least one person in Ontario who's being prosecuted for not disclosing their HIV positive status before sex without a condom, even though they had a low viral load or under 1,500 copies of HIV per milliliter of blood. So in other words, the law is still unsettled and people living with HIV in this circumstance are still at risk of getting charged. And this is kind of common that you'll see across all the scenarios. The law is still evolving. It's still unsettled. And our last scenario, so oral sex. We know from science that the possibility of transmission during a single act of oral sex ranges from negligible And this is usually in really sort of unusual and extreme circumstances, to none, right? So in Ontario, prosecutorial policy and instructions don't say anything about oral sex. But based on the legal network's correspondence with the Ontario Ministry of the Attorney General, again, we know that people living with HIV who do not have a suppressed or undetectable viral load are still at risk of prosecutions for engaging in oral sex without disclosing their status. And it's worth noting that people have been charged for oral sex alone without disclosing, but such prosecutions are actually quite rare. People are usually charged with oral sex in combination with other sexual acts, such as vaginal or anal sex. And in at least one case in Ontario in 2013, a lower court accepted that oral sex does not amount to a realistic possibility of transmission. So again, the law is still unsettled, unfortunately. So I'm going to show another video just so that I can take a sip of water. And this one is by Extra Magazine, and it explains why Canada's criminalization of HIV non-disclosure really makes no sense before I sort of move into my own observations.
People living with HIV in Canada continue to be singled out for allegedly not disclosing their HIV positive status to their sexual partners. My name is Nick Kevanu. I'm a lawyer at the Canadian HIV/AIDS Legal Network. Canada's approach to the criminalization of HIV is unjust, unscientific, and it undermines public health. There have now been over 200 prosecutions in Canada, which is one of the highest rates of HIV criminalization in the world. The Legal Network is asking the government to reform the criminal code to end the unjust prosecution of people living with HIV. Canada's approach is at odds with public health objectives, and it may actually be fueling the spread of HIV. We have no evidence whatsoever that HIV criminalization helps lower HIV transmission rates. The law only applies to those who are aware of their HIV status. So if you think about it, we're actually giving people a reason not to get tested and driving them away from the medical system. People continue to be prosecuted in Canada even when there's little to no risk of transmission. The problem with the law is that it has not caught up with the science of HIV. We have medications today that reduce the risk of transmitting HIV to effectively zero, and yet people are still being prosecuted. So in our view, those prosecutions are based on fear and outdated medical knowledge. Police and prosecutors have relied on the charge of aggravated sexual assault to prosecute people living with HIV. It's one of the most serious crimes in the criminal code. It carries with it a maximum sentence of life in prison and placement on the sex offender registry. People living with HIV have also been charged under other sections of the criminal code that include the administration of a noxious substance, false pretenses, and even murder and attempted murder. The average prison sentence for a person convicted under an HIV-related offense is more than double the average sentence for sexual assaults in Canada. The overly broad use of the criminal law against people living with HIV undermines the human rights of people living with HIV, who are often members of other marginalized or criminalized communities. We know that the proportion of Black men as well as gay men being charged has been increasing. Among women being prosecuted, marginalized women are overrepresented, including women in poverty, women who are survivors of sexual violence, and women with insecure immigration status. We've heard from women whose vindictive partners have threatened to report them to the police for not disclosing their HIV status, whether or not that was true. So it's clear that the overly broad use of the criminal law against people living with HIV is unfair, it undermines human rights, it's out of step with the science, and it needs to change. In particular, we're asking that HIV be removed from the law of sexual assault and that prosecutions never occur unless there is actual intentional transmission of HIV.
Perfect. I love that video. I think it summarizes everything that I talked about up until that point and also introduces some of the harms of the law. So for the past year, I've been interviewing people living with HIV and some people who are HIV negative but have experienced HIV non-disclosure about experiencing non-disclosure from a sexual partner. So I've been really trying to understand how it is that people feel when they experience HIV non-disclosure from a sexual partner, which includes, you know, some of their responses to hearing the information, including why they might choose to go to the police or not go to the police. So while I'm not at the stage just yet of presenting the results, I did want to sort of share some general things that I heard from participants as well as findings from other research about how harmful the law is. But I do promise that I do have a technical report and a picture book that's going to come out for my research. And it's going to highlight a few different perspectives of people I've interviewed, including a person who was criminalized for HIV non-disclosure, someone who is HIV negative but experienced HIV non-disclosure from a sexual partner, and someone who reported their experience of HIV non-disclosure to the police. So maybe that'll be a second presentation that we can talk about, Khaled. So first thing that personally frustrates me about the law is that it assumes people living with HIV don't disclose their status to their sexual partners because they're trying to be malicious, that they're trying to spread the virus, or because they're inherently bad people. But we know from past research and things that I've heard from the folks that I've interviewed is that people living with HIV think about disclosure almost all the time. And not just disclosure to their sexual partners, but disclosure to their dentist, to their massage therapist, to their chiro, to their employer and colleagues, to their family. And so one thing we know about disclosure is that it's extremely difficult, and especially to someone close to you, right? So it's not that people living with HIV go out of their way not to disclose their status. It's a very personal decision that has real consequences for some people. So for instance, I heard from participants that when they did choose to disclose to their partners, some of them experienced violence and rejection, while others experienced acceptance, love, and support. So really, it's almost a calculation that has to be made on the part of people living with HIV. And this calculation is a really tough one, and one that the law really has no business intervening in, right? The law isn't good at handling these kinds of moments in people's lives, nor should it. I also heard from a lot of participants that HIV, even with all the associated struggles of experiencing stigma and rejection, that it changed them in not necessarily negative ways, but sometimes, as they would say, for the better. So this included allowing them to make tough decisions about who they wanted in their lives and who they didn't want in their lives, how they wanted to live their lives. And sometimes it offered them a sense of community, a chosen family of sorts. So what the law does by criminalizing HIV non-disclosure is propagate not only HIV stigma, but also this assumption that HIV is a deadly disease to be feared when we know this isn't the case. We know that people can live long, healthy lives, especially with the knowledge we have about U equals U. And this is sort of an aside, I think part of the reason why we have this image of HIV as a deadly disease to this day, aside from the law, and this is something that I had conversations with some of my participants, is that TV shows and movies that are about HIV continue to portray HIV as people experienced it in the early days of the pandemic. And while this is important, we don't really have images of people who are living with HIV today and who are successful and thriving. I mean, I think that kind of work is starting to come about. I know Billy Porter, who came out recently, and some of the queens that participate in RuPaul's Drag Race, right? So we're starting to see more of these images. But these are the kinds of images, I think at least, that we need in addition to the abolition of this law in order to change this mentality about HIV as a deadly disease. So, if you have thoughts, we can have a conversation about that. You can feel free to email me. But sort of shifting back to the law. So one of the most harmful effects of the law is that it creates this assumption that only people living with HIV are responsible for disclosing. So the law, in a sense, creates this false sense of security amongst HIV negative people because they now believe that the law will force people to disclose and therefore that they don't have any obligation to practice safe sex. So really the law downloads all of the responsibility for safe sex onto the person living with HIV. And it makes them responsible for not only their own health, but the health of their partners as well. So in response to this, one of my participants told me something that's really stuck with me to this day. And I I can't forget it and I don't want to forget it. So this person said, that if we expect people living with HIV to disclose to us, and this is what the law wants, we need to think about whether or not we are creating the conditions necessary for someone to disclose to us. So whenever someone is feeling angry or betrayed or upset, when a partner or anyone in their life doesn't tell them something deeply personal, like being HIV positive, then we should take a step back and ask ourselves whether we have made the appropriate conditions for that person to disclose. Have we created a safe space? Have we shown that person that we are someone that they can confide in? And I think this is a really important point that I want to instill in people watching this presentation, and particularly with regards to the law, right? The law really isn't creating this safe space for people living with HIV to feel comfortable coming forward. And so this has detrimental effects for testing and for access to HIV care, right? So the law actually deters access to HIV care and treatment by undermining the relationship between counselors, medical professionals such as nurses and doctors, and people living with HIV. So this is because the records of medical professionals can and have been used in court as evidence, and these professionals can be compelled to testify in court against their patients. So really, it undermines that relationship between patient and healthcare practitioner, right? If we can't confide in our healthcare practitioners to keep our information private, then are we going to access that care? So that's really problematic. And criminalization also profoundly affects people's lives. It adds another layer of stigma, and it's extremely traumatizing. So one of the people I interviewed who was criminalized for HIV non-disclosure stated that being on the sex offender registry actually made her feel disgusting and dirty. And because her case was so heavily covered by the media, she had said that she felt like people knew of her and they knew her story, but they didn't really know her as a person. So in a sense, she felt at the same time both hyper visible and invisible at the same time. So it's this layering of stigma of criminalization of HIV that has really profound effects on people's lives, and just another reason why we need to stop criminalizing HIV non-disclosure. And sort of the last harm that I want to draw your attention to is that it's really problematic to send people living with HIV to prison. So while the criminalization of HIV non-disclosure is often justified under this rhetoric of protecting the public and stopping the spread of HIV, sending people living with HIV to prison neglects the fact that prisons are spaces where there is an elevated risk of HIV transmission. Not to mention that a person living with HIV in prison, potentially their health can deteriorate. Right? I've heard from participants who were living with HIV and have been imprisoned that sometimes they don't have access to their medication, and that has really detrimental effects for their health. So all around, it's bad. It's bad policy, and it needs to change. So one of the most recent, and I put a question mark beside recent because it's not that recent anymore, sort of news towards positive change was received on World AIDS Day in 2016, when the Federal Attorney General and Minister of Justice, the Honorable Jody Wilson-Raybould, issued a statement recognizing the problem of overcriminalization. So a year later, the Department of Justice actually released a report that was entitled Criminal Justice System's Response to the Non-Disclosure of HIV, which offered a few recommendations for limiting prosecutions against people living with HIV. And then finally, in December of 2018, and based on this report, the Federal Attorney General issued a federally binding directive to the Public Prosecution Service of Canada regarding HIV non-disclosure to sort of serve as a guide for federal prosecutors. So the document states that cases of HIV non-disclosure should not be prosecuted where the person living with HIV has maintained a suppressed viral load, so under 200 copies per milliliter of blood, because this scenario doesn't constitute a realistic possibility of transmission. The directive also states that Crown will generally not prosecute cases in which the person does not have a suppressed viral load, but wore a condom or engaged only in oral sex or was taking their treatment as prescribed. So this also doesn't constitute a realistic possibility of transmission. Crown will, however, prosecute HIV non-disclosure cases using only charges that are non-sexual, and that decisions to pursue prosecution should be based on whether, and I quote, it is in the public interest to pursue a prosecution against that person. So, of course, this begs the question of who is considered the public in public interest. Who is this law trying to protect? While these directives are laudable, they actually only apply to federal prosecutions and thus govern criminal code prosecutions in the 3 territories. So the Yukon, the Northwest Territories, and Nunavut. The 10 provinces are under the jurisdiction of their provincial attorney generals. And since 2019, only BC and Ontario have made their own specific directives, and some of which we went over when we went over the scenarios. So there are a number of organizations, including the HIV/AIDS Legal Network, HALCO, and Katie, who not only offer legal advice, but they also advocate on behalf of people living with HIV and intervene in HIV non-disclosure cases. So there is also a coalition to reform HIV criminalization that was formed in 2016 to reform discriminatory and unjust criminal and public health laws and practices that criminalize and regulate people living with HIV. So the coalition consists of people living with HIV, community organizations, lawyers, researchers. And in 2017, they released a community consensus statement on ending unjust HIV criminalization that's actually endorsed by more than 170 community organizations from every part of Canada. And this statement calls for criminal prosecutions to be limited to cases of actual intentional transmission of HIV in accordance with international guidance, that federal and provincial attorney generals develop sound prosecutorial guidelines to prevent unjust HIV prosecution, that the federal government reform the criminal code to limit unjust use of criminal law against people living with HIV, and that all governments support the development of resources and training for judges, police, Crown, prosecutors, and prison staff to address misinformation, fear, and stigma related to HIV. And more recently, actually, they have started a series of community consultations to understand the best way forward in addressing criminal legal reform for HIV non-disclosure. So keep an eye out for that in your communities. And, they're always looking for more people living with HIV to become involved. So if you're interested, you can send me an email. I can put you in touch with folks who are on the coalition and you can join up. And I think Max Ottawa will have contacts as well. So you can also contact Max. And so the sort of last couple of slides here is information. So this is the stuff that Khaled will post in the comments and on the YouTube description. So after hearing the presentation today, if you feel, that you need to chat with someone about your situation or something, these are the 2 organizations that I would say to reach out to. They can help connect you to a lawyer if that's what you need, or simply give you more information about the law because they're lawyers, so they're going to have a lot more information. And then I also have a page of other useful resources, some videos that we didn't get a chance to watch today, but that are pretty informative. And then also a few different websites. And I want to point out the HIV Justice Worldwide website. So I've talked really only about Canada today, but that website is a really good resource if you want to learn more about the criminalization of HIV non-disclosure globally. And that's my presentation. Thank you all so much for watching. This is my information, so my email. I do have a personal website that you can check out. And the dissertation website, I will be posting any sort of reports and things that come out of my project on there. So you can sort of check in once in a while if you're interested, and that information will be there. Thank you, guys.
Thank you, Katerina. I did add your email, your website, katarinabogosavljevic.com, in the comments. I am not able to add the resources in the comment section. I was just able to only send one comment, but I will make sure to add them in the YouTube description. And then if you email us or Katarina, we can send them to you. I think, and your email address is, I'll just add your email address on the chat.
Yeah, I don't know if I can add to the chat. I can also write it too. I don't think I can.
We do have 10 minutes, 14 minutes for questions. And if you're shy or if you want to ask your question later, you can always email us or email Katerina. Katerina, I have to
about the information. If you need to think about the information, you can email me later too. I'm around. I'm available. So
thank you, Katerina. I do have 2 questions for you, and the first question is, so as a researcher, in your work as a researcher, did you notice differences between 2 different demographic groups, queer people and cis straight people?
Yeah. So the one person that I actually interviewed that did end up going to the police was a cis straight woman. And so I think, I can't say anything quite yet because I haven't analyzed the information yet, but just sort of generally what I would say is that straight people, and as someone who identifies as straight, we don't have a lot of information about HIV. And I will full-heartedly admit that I didn't have a lot of information about HIV before I started studying the criminalization of HIV non-disclosure. This is where I learned a lot of this information. So I think that is a huge difference and something that I think might be motivating, in particular, straight women to go to the police. I can't sort of confirm this, and I don't want to paint everybody with the same brush, of course. But I definitely think HIV education targeted more towards straight people is needed. I really don't think we talk about it enough.
Thank you, Kat. We have a question in the chat. I'll just read it to you. Thanks for this great presentation. Case law and definitions seem to refer to condoms as the only recognized way of protection. Is there any recognition of PrEP efficiency?
Nope. I mean, I don't want to say no completely because I'm not a lawyer, so I'm not really sort of directly involved in some of the cases, and especially staying like super up to date with the case law. But from the things that I know, no, I don't. It's condoms, and it is talk of low viral load, or like U equals U. I mean, just trying to get like U equals U recognized by the courts, I think has been a battle. So yeah, there's lots of work to be done, I think. Thank you for that question. I think that's an important point to consider.
Thank you, Kat and
Hopefully that answers your question. Sorry.
Oh yeah,
it's not a very positive answer.
My second question is so what recommendation could you make to health organization that support people affected by the criminalization of HIV?
So I want to answer this question. I'll draw it back to what I said in the presentation about disclosure. So I think as a sexual health organization, I think education around how to receive that information, right? Like we have training for people in terms of how to receive someone that tells them that they were sexually assaulted, for example. So I think some sort of similar training in that way to how to like make that safe space to allow people to come forward. And I know that's not an easy feat because it's not just about sort of changing individual people. It's about changing the whole mentality around HIV and reducing stigma. So there's, I think, a lot of work to be done, but I think that's a really positive thing that could be done. And also what I just said, more education information targeted towards straight folks, trying to get this information in schools, although I know that's also politicized heavily. So yeah, those would be sort of my recommendations.
Thank you, Kat. I don't see other questions.
Maybe information needs to marinate in people's brains. It's okay.
Oh yeah, definitely. I have to go through the presentation again.
It's a lot of information, and it's a lot of information that isn't clear. I mean, when I was making this presentation, and even when I'm writing, papers and other things related to this topic, I have to like double check 50 times in order to really understand. Okay, so like what scenario is criminalized? What isn't? Like it's really complicated. So if it's complicated to someone who's sort of studying this and reading some of this case law, imagine how it is for people on the ground that have to make these decisions, right? And like, this is the other sort of really frustrating thing about the law is that now that the law is involved, these decisions become even harder and even more complicated. Yeah. We have another question too.
We have a question, yes, from Robin, so I'll read it. When speaking out against this issue, have you found any particular talking points to be most effective at convincing people to start changing their minds?
Yeah, this is such a great question. I wouldn't say specific talking points. What I would say is what I think really gets people are stories, personal stories. And I know that Alexander McClellan, so he did his dissertation where he interviewed people who were criminalized for HIV non-disclosure, and he put out this really great booklet that outlines the stories of the different people that he talked to. And I think using that information and talking about how traumatizing, how stigmatizing criminalization is for folks who've experienced it, I think that's a really powerful message. But I have also gotten, pushback from friends and people that I've spoken to about this, because they're like, well, yeah, they should disclose. We should know this information, before we have sex. And so, I always say back to what that participant said, now that I have that tool, well, it's like, okay, but if you have this expectation that someone should disclose to you before you have sex with them, what have you done to let this person know that it's a safe space to disclose, that they can disclose to you? I think that's a really powerful talking point as well, hence why I wanted to bring it up today. So hopefully that answers your question.
Thank you, Kat and Robin. I think there's also, I think I'm not receiving maybe all the questions. No, I think I'm good. This is our first Facebook Live using this platform.
Seems to be working pretty well. The questions are coming in. So.
I see also people are reacting to the presentation. We have likes and hearts. And thank you.
Excellent.
Thank you, Kat. Thank you so much for presenting today and sharing your email address and website. Oh, we have another heart. I will share, I will download this live Facebook event and upload it on Facebook, and then make sure to add all the resources that you shared with me in the description. So thank you so much, and I hope you'll have a great long weekend.
Thank you. Thank you everyone for watching and for asking such great questions. I really appreciate it, and I hope you all have a great long weekend. It's supposed to be an amazing day today if you're in Ottawa, if you're watching from Ottawa. So I plan on going out there for a walk after this.
Thank you. Thank you, everybody. Bye-bye.
All right. Bye, everyone.